Brian Moore and Cristal Starling both lost their money to civil forfeiture, despite neither of them being charged with a crime. They both challenged those forfeitures and got their money back, but the government refused to make them whole. I'm Kim Norberg of the nonprofit civil liberties law firm, the Institute for Justice, joined by co-host Keith Neely. We're here with IJ senior attorneys Dan Alban and Paul Sherman to discuss two cases under the Civil Asset Forfeiture Reform Act, a law that's supposed to protect innocent victims of wrongful forfeitures. This is Beyond the Brief. So Dan, we recently secured a win in a civil forfeiture case in Atlanta. Can you tell us what was going on there?
Sure. We represented Brian Moore Jr., a U.S. Army veteran who had decided to try to make a music career and was flying to Los Angeles to visit his brother, who had contacts in the music industry and the video recording industry, and he was going to shoot a music video there. He had about $8,500, which came from the sale of a vehicle that he had inherited from his grandfather. And as he was at his gate, DEA agents approached him, searched him, interrogated him, and seized the money. There was no evidence that he was involved in anything illegal. He was just a black guy with green hair and $8,500 at the Atlanta airport. Now, he was able, unlike many people, to find representation, not by IJ, but by private attorneys in Tampa, Florida. And they were able to win his case, filing a number of motions, including a motion for summary judgment, a motion to suppress the search, all sorts of things. And the government threw in a towel and just gave up and said, we're willing to dismiss this case with prejudice. Brian will get all of his money back. But then, when Brian's attorneys moved for attorney's fees under something called the Civil Asset Forfeiture Reform Act, a federal statute, the judge said that he had not substantially prevailed and thus wasn't eligible for fees. And because of that, Brian ended up out the money that he had to pay his attorneys to get his money back.
So there's a lot of stuff going on there that, a lot of our listeners are familiar with civil forfeiture, but some of the mechanics of this might be a bit new. So can you explain, what does it mean to dismiss something with prejudice, like as opposed to what, and, what's the significance of that?
Sure. So a dismissal with prejudice means the government cannot bring the suit again. So any kind of case can be dismissed with prejudice. It just means, plaintiff, you're not allowed to sue the defendant again, at least over whatever the issue is that you're suing about. And in this case, it would have meant that the government could not have tried to forfeit his money a second time. So it means he was safe, and he got his money back. That was game over. There was nothing left for the government to do, and Brian had all of his money. So he had, in fact, substantially prevailed because he won in every possible way you could win.
So how are attorney's fees sort of supposed to work under the CAFRA statute?
Sure. So under CAFRA, if a party substantially prevails, meaning a forfeiture victim, a property owner, if they are able to get back all or most of their property, they are able to apply for fees, and the court is supposed to award reasonable fees and costs. So essentially the costs that they spent on their attorneys and on the legal filing fees, they're supposed to get back. The idea is it is supposed to make property owners whole after they've had to go through this entire process, after they've been, at least temporarily deprived of their property. Once they win and they get it back, they're supposed to be made whole by having their attorney's fees and legal costs paid.
Why is that important? Like what amount of attorney fees are we talking about in this particular case?
Sure. So often the cost to litigate a forfeiture case is as much or more than the value of the property that is seized.
I see.
The median level of a cash forfeiture from 2015 to 2018 was approximately $1,300 across 22 states. And so you can imagine you could eat through $1,300 worth of legal fees in just a few hours. And so most people can't afford to hire an attorney as a practical matter because they would spend thousands on legal fees to get back less. And that's actually true in Brian's case. He had $8,500 seized. His attorneys billed approximately $15,000 in legal fees, getting his money back. And so almost twice what was seized is what it cost him to get it back. But the idea is, if the government is going to initiate a seizure and forfeiture proceedings and make someone go through all of this, and yet they still win, the government is supposed to pick up those fees so that innocent people aren't, having their lives irrevocably damaged by, having their life savings seized or, whatever it is that's seized.
Paul, attorney fees normally don't work this way. Typically, in American law, each party bears their own costs in a suit. CAFRA is different. Why is CAFRA different, and why is that difference important?
Yeah, so America follows what is widely called the American rule.
Right.
Aptly named.
Yeah, and really there's kind of the American rule and what might be called like the rest of the world rule. America is somewhat unique in that parties almost always bear their own legal costs. Fee shifting provisions like the provision in CAFRA are imposed by Congress when they don't want people to be disincentivized by the cost of litigation from taking cases to court. So civil forfeiture is a classic example. As Dan just said, the cost of trying to win one of these cases often exceeds the amount that's seized. So fee shifting helps you get that money back. We also have the same thing in a lot of civil rights cases where we don't want people who can't afford to vindicate their First Amendment rights or their Fourth Amendment rights to not go to court. So in those cases, if you prevail, you can get your money back.
So what happened after we started getting involved in Brian's case?
So we were contacted by the attorneys in Tampa who are part of our network of forfeiture attorneys across the country. They emailed us as soon as they got this bad decision, said, "We think this is crazy. What do you think?" I said, "Yeah, I agree." And we agreed to take over the appeal, and we filed our briefs. We went up to the 11th Circuit. About a year ago, we argued the case down in Atlanta in front of a 3-judge panel. And just this past August, we got a ruling that Brian did indeed substantially prevail. He is entitled to his attorney's fees and costs. And so we're in the middle of filing for those costs and fees now.
This seems like such a commonsensical answer in this case. What reason did the district court give for denying fees and saying that he did not substantially prevail?
So the district court judge ruled that because Brian had not prevailed on the merits, he had not substantially prevailed.
I see.
Now, that's kind of a legal term of art, but it means Brian didn't in court show that the money was from a legal source and for a legal purpose and secure a ruling that the government was wrong about its allegations. Instead, the government simply gave up and agreed to voluntarily dismiss his case with prejudice. For some reason, the district court judge thought that meant that Brian wasn't entitled to fees, even though when you are a defendant, or in Brian's case, a claimant to property, it doesn't matter how you win. What you want is to win. You want to have the case against you or your property dropped, and that's what happened. So sort of a confusing justification for the ruling, which is why we appealed.
So, Paul, we have another client who, was in a sort of a different civil forfeiture situation, but then ended up in a similar place to Brian of dealing with the issue of fees and everything like that. So can you tell us about Crystal Starling and what initially happened in her case?
Yeah, so Crystal Starling lives in Rochester, New York. She operates a food cart to help care for her grandnephew. And she was saving up money so that she could buy a food truck and hopefully secure a better income for herself. While that was going on, she was dating a man who police suspected of being involved in drugs. And one night they executed a search warrant on her apartment and on another location that was associated with the now ex-boyfriend. At the other location, they found drugs. At Crystal's apartment, they didn't find any drugs, but what they did find is the money that she'd been saving in her dresser drawer. And they seized it. It amounted to $8,040. Unlike our other client, Crystal couldn't afford a lawyer. She knew that it was going to cost more than what was seized, so she decided to contest the forfeiture herself. And this is where we get into some of the real difficulties that pro se unrepresented people have navigating this system. So the first thing was that the government tried to administratively forfeit the money, where they said, we want to forfeit the money. So she had to object to that. And when she objected to that, it started a judicial process. Once the judicial process started, the government had to move in court to forfeit it. And they sent the paperwork to her while she was on vacation. She missed it. She gets back from vacation. She waits some months. Meanwhile, her former boyfriend is acquitted on all of the criminal charges, and she is never charged with anything. So she writes into the court. She says, hey, I want to continue fighting for my money to get it back. And the government says, well, you defaulted. You missed the deadline, so the money is ours to keep. We don't even have to put up a fight. She tries to fight the default. The district court rules against her. That's when IJ got involved and took her appeal to the Second Circuit. And we were able to convince the Second Circuit that as a pro se litigant, she had done everything she reasonably could have. She made honest mistakes. She should have a chance to fight this. The case is remanded to the district court, and then, much like in the case Dan was talking about, the government immediately surrenders, or at least tries to surrender, because a big incentive for this money is they want to take it when it's cheap and easy. They don't want to have to fight for it when it's small amounts. So the government returns her money. They try to voluntarily dismiss the case, which is just when they say unilaterally, we're dismissing this case. We objected to that because she had already started the legal process. They were not entitled to dismiss the case on their own. So then they say, okay, well, then we want to voluntarily dismiss the case without prejudice. Without prejudice means that theoretically in the future they could refile the case. We had a fight in the district court about whether dismissal should be with prejudice or without prejudice. They stated that they weren't going to refile the case.
We're not going to refile it, but we want to retain our ability to refile it.
Yeah, we want to keep the option. We've changed our policy so that we don't forfeit amounts that are this low anymore, but dismissal should be without prejudice. As we explained to the district court, under the prevailing approach, this means that she would be denied attorney's fees and interest for the time that she was deprived of their money. And the district court issued a ruling where he said, well, that's not a meaningful prejudice, and also I'm going to dismiss the case without prejudice, and as a result, it denied our request for fees. We're appealing that now to the Second Circuit Court of Appeals, and I think this shows a real blind spot in the way courts are approaching these laws, because this is what the government does again and again and again. We've seen it in a bunch of IJ cases where when someone is unrepresented, government is fine pushing them around trying to take their money. When IJ enters the case, suddenly, sometimes the same day, the government gives the money back. If that's the case, then the government doesn't really believe that it's seizing that money for a proper purpose. And it should have to compensate people for the time and the effort they spend trying to get that money back.
Can we talk about the default part a little bit? Because this initially happened years ago, I think, with Crystal. And if she had, really defaulted on this forfeiture and, wasn't able to revive the case, this all would have been over years ago. And so how does it work with her as you said, a pro se litigant, which basically just means somebody representing themselves, right? Do courts have different rules when lawyers are involved versus when you're representing yourself? Like how important is this kind of default issue when IJ's involved versus when IJ's not involved?
Yeah, so typically courts are more relaxed with the way they treat unrepresented people because they know they're not lawyers, they don't know all of the technicalities. And part of what the Second Circuit held is that here the district court held Crystal to too high a standard. So there are different standards that apply when you miss important deadlines in court. One of them is excusable neglect, which is actually a very high standard. You have to show that there was some overwhelming reason why you couldn't do this. Another is just good cause, if you're asking the court to reopen and allow you to make up for a missed deadline. And what the Court of Appeals held is that Crystal should have been held to the ordinary good cause standard, and that here she clearly had good cause. The worst that you could say about her is that she had been misadvised by a state district attorney about when she could file, because under state law, she was not able to file until her ex-boyfriend was acquitted. That did not apply to the federal forfeiture, because this was one of the situations that we deal with a lot, where the state initially seizes the money and then transfers it to the DEA or another federal agency, which adopts the forfeiture. And then it's governed by federal rules, which are different.
Did you know IJ represents ordinary people, free of charge, as they fight back against government abuse? If you're looking for a rewarding way to support our work, consider becoming a member of our merry band of monthly donors and stand shoulder to shoulder with IJ's clients every month of the year. Monthly donations are convenient and cost-efficient, meaning more of your money goes directly to our fight for freedom and justice. Sign up to donate today at ij.org/monthly.
So we have one case where a person's case, forfeiture action, was dismissed with prejudice, one where it was dismissed without prejudice, and that seemed to make all the difference in whether that person got attorney fees or not. Is that the dividing line that courts across the country are drawing, or is this something that's specific to these two cases? If courts are drawing the line in a different place, where are they drawing it?
That's pretty much the line that people are drawing. And the reason, unfortunately, is because they're looking to a set of attorney's fees cases that I mentioned earlier involving civil rights law, which also has fee shifting, but has different statutory language granting the fee shifting. So in an ordinary civil rights case, you are entitled to attorney's fees generally if you are a prevailing party. And the U.S. Supreme Court has said that to be a prevailing party, you have to get some order from a court that changes the legal relationship between the parties. Dismissal with prejudice changes the legal relationship between the parties because the government no longer has the right to go after you for that money. But what these courts are holding is that dismissal without prejudice does not change the legal relationship between the parties. The problem with that reasoning is that the statutory language is different, because CAFRA does not say prevailing parties get their fees. It says anyone who substantially prevails gets their fees. And in an asset forfeiture case, all you want is to get your money back. If you get your money back and the government surrenders, and particularly in a case like Crystal's, where it says we've changed our policy, we'll never seize amounts like this again, by any reasonable use of the English language, you have substantially prevailed. Unfortunately, courts have not really homed in on that statutory difference, but that's part of the reason why we're appealing her case to the Second Circuit again, because the language of statutes matters, and Congress wanted to make forfeiture victims whole when they're in situations like Crystal is in.
I think the second order problem, and Dan, maybe you can touch on this a little bit, because I think, Paul, you kind of hinted at it. In these sorts of cases, the government gets a lot of sway in deciding whether a case is dismissed with prejudice or without prejudice. So if the courts are right that distinction is what matters, and the government has the power to push a case all the way to the end of the road, and then at the very last stop say, actually, you know what, we're going to dismiss without prejudice, and we're going to avoid all of the fee-shifting provisions of CAFRA. That sounds like a pretty substantial problem.
Oh, yeah, it's a huge problem, and it unfortunately happens all the time. It encourages very bad behavior. It encourages these sort of abusive tactics that can draw out litigation for years, on the theory that basically someone's eventually going to give up. They're either going to run out of money to pay their attorney, or they're just going to get tired of fighting it, tired of trying to show up for depositions or produce documents in discovery or file things in court, and they'll lose. And that is actually a very successful tactic for the government. That is normally what does happen. People generally settle their cases because they don't want to have to wait out until they finally get a ruling from the court. And so when someone does litigate, as far as, for instance, Brian did and his attorneys at the Samus law firm in Tampa, it costs money. It takes real attorney time to put together, discovery motions to suppress, motions for summary judgment. And they had two of these essentially dispositive motions pending at the time the government decided to dismiss the case. Now, the other problem is that, of course, the government gets to tell the judge, hey, we think this should be dismissed with or without prejudice. And usually they'll offer some reasoning for why it should be dismissed without prejudice that sounds sort of like, well, after careful investigation, and all of the discovery in the case, we were finally able to determine that, it did not make sense for us to pursue the forfeiture of this property, either because, we're not sure we're going to be able to satisfy our burden at trial, or our policies have changed. We now no longer go after these small amounts, or, they'll come up with something and make it sound sort of like, well, this is just in the interest of justice. But of course, the person who had their stuff seized didn't have any choice in any of this, was just going about their business one day, and suddenly DEA agents swarm them, take their stuff, and their life's turned upside down. And courts sometimes fail to factor that in, and are often very willing to do what the government wants done. A lot of judges are former government attorneys, sometimes former prosecutors, and so they've been in the same shoes as the U.S. attorneys or AUSAs that are petitioning them. And so very often those motions to dismiss without prejudice are granted, and of course that means all the prejudice actually falls on the property owner, who bears the costs of having to vindicate their own rights, get their property back, and often at tremendous cost.
It all seems a little too convenient for the government, right? Because if they're basically, what's happening is they're just seizing money from a bunch of random people. Some small fraction of those people figure out how to fight back, and then the government, draws it out to the 11th hour, throws the property back, and then, but doesn't give the property back to everybody else, right? They'll say, oh, our, policies changed or whatever, but if that's true and that's a reason for getting rid of this case, surely that's also a reason for getting rid of the cases of all of the property that you kept, right? And so it seems kind of obviously a hollow justification.
Yeah, it does make you suspicious, doesn't it?
Just a little.
Just a little bit.
It's part of a sort of catch and release fishing expedition that is part of pretty much all interdiction efforts that lead to civil forfeiture, whether it's airport interdiction or highway interdiction. The idea is seize as much cash as you can, vacuum up all the cash on the highway, and you can sort it out later, whether, someone is, actually involved in drug trafficking or just somebody who's, traveling down the road to buy a used car. And in that process, most of the fish that you catch aren't able to wriggle out of it and get their money back. And so the government ends up with most of the cash and only a handful of people able to fight back. And then even at the end of the road for those people, they're sometimes not getting their attorney's fees. And so it's not a very fair system. And it's certainly not the system that Congress imagined when it passed CAFRA back in 2000. The idea at the time, there were a number of horror stories that were sort of brought before Congress. Some people testified about how they lost their plane, various other things that were destroyed or lost as part of civil forfeiture cases. And Congress said that shouldn't happen to people who are actually innocent. And so if you prevail in your case, you should have your attorney's fees covered and be made whole. And of course, if the government has an end run around that at the last minute, saying, "Oh, never mind, just dismiss without prejudice," then that kind of guts CAFRA's attorney's fees provision.
I think this also shows how far modern civil forfeiture has moved from its historical origins. So the reason we even have something like civil forfeiture comes out of admiralty law, because you would be dealing with things like smugglers who may be on the other side of the planet. You can't exercise jurisdiction over the smuggler, but you can exercise jurisdiction over the ship. And if you look back at old Supreme Court cases, you'll see all these cases that are named just after boats. And then it started to expand during Prohibition. We're seizing, cars that have been modified to hide alcohol. And then it really explodes with the war on drugs, and the focus shifts away from removing the instrumentalities of crimes or contraband or even necessarily the proceeds of crimes, just to seizing cash. And, often on the flimsiest of pretexts, a drug dog will seemingly alert on cash. Virtually all cash in the United States is contaminated with trace amounts of drugs. And then suddenly the burden is on you as the property owner to try and get your money back. And we've set up a system where there are traps for the unwary at every single step. They'll do an administrative forfeiture. If you miss the paperwork for that, you lose your money. If you file the paperwork, suddenly you're in court trying to defend the forfeiture. If you miss the paperwork for that, you're in default and you'll lose your money. And if you successfully make it through that, then they'll say, well, first they'll offer to settle. They'll say, we'll just give you half the money back. For a lot of people, that's enough to end the nightmare. Crystal refused an offer like that. And then at the end of the day, if it looks like they're really going to have to dig in their heels and fight, they'll say, okay, well, we'll just give you all the money back. We're going to dismiss without prejudice. And then you've spent years of your life and maybe thousands and thousands of dollars defending yourself. The government doesn't owe you anything after that.
I imagine it's hard to listen to this discussion and not be asking, whether IJ gets attorney's fees through CAFRA. So can you talk about that a little bit? How does this relate to us specifically?
Yeah, so in CAFRA cases where we represent people successfully and we're able to secure them a ruling that a judge holds does trigger the fee shifting provision, then we are able to recover our reasonable attorney's fees. That's for the time that we actually work on the case, not for time that other attorneys worked on the case. Those attorneys can be entitled to those fees, and not for time when the client was represented pro se. When they don't have an attorney, we don't get to hypothetically collect fees for them in that instance. That's the same basically as a lot of our federal civil rights work, which also allows us to recover attorney's fees if we're successful.
Are fees available theoretically available in every case? And if we get them, does it sort of fully cover the cost of doing the case, or is there, a lot of gap?
No. So fees are available in kind of narrow bands of cases. If you're suing a state for federal civil rights violations, typically you can get some fees. In CAFRA, you can get fees. There are other fee-shifting provisions. Some of them are much harder to satisfy. If you're suing the federal government, for example, you have to not only prevail, but show that the government's position was not substantially justified. That's a much higher burden, and you can win a great case and still not, win a great case and still not be entitled to fees. As for whether it really makes you whole, no, it doesn't, for a couple of reasons. Number one, IJ puts a lot of work into our cases. Our lawyers typically have quite low caseloads compared to private lawyers because our focus is on establishing this precedent. We put way more work into our cases, and judges would just not compensate us for the amount of hours that we put into our cases. The other thing is that we typically can't recover the kinds of attorney hours, hourly fees that we would charge if we were in private practice. You've got attorneys at IJ with 20 years of experience. They'd be senior partners at big law firms if they hadn't devoted their lives to this. They'd be billing $1,000, $1,500, maybe $2,000 an hour at some firms. We can ask for much, much less than that when we move for fees, sometimes as low as a couple $100 an hour, depending on the jurisdiction. So in the end, it helps. It's a useful part of our budget, but because it's so inconsistent and because it doesn't actually cover the cost of the litigation, it's not something that we factor into our decisions about whether to take a case. We take every case regardless of whether we think we can recover attorney's fees.
And fees don't cover people who aren't attorneys, right? And so a big part of our work involves communications and research and this sort of, multi-pronged effort to make sure that the public is aware of what's going on and all of that, and to kind of generate support for the issues that we're working on. And fees don't cover any of that, right?
That's right. It covers attorneys. It can cover the paralegal staff who work on the cases with us. And it can cover, these aren't fees, but they're costs. It can cover some of the costs associated with litigation, printing costs, filing fees,
stuff,
things
yeah.
like that. But all of our work communicating to the public, trying to mobilize support, doing original strategic research that shows the extent of these violations, which can be extremely valuable to the litigation itself. None of that is covered by attorneys' fees.
To sort of wrap up, I believe that CAFRA was passed some 20, 25 years ago. Have there been any other forfeiture reforms at the federal level since then?
Since CAFRA was passed in 2000, there's only been one forfeiture reform legislation that was passed. It was the Clyde Hirsch-Sowers Respect Act, named after some of our clients. And it was in response to the IRS's abusive seizures of business bank accounts because of what they believed was structuring transactions where businesses were frequently depositing less than $10,000 on a regular basis. And federal law says if you have more than $10,000 to deposit, you can't break it up into smaller amounts to avoid the reporting requirement that comes with a $10,000 deposit. What the IRS failed to understand is that lots of small businesses have cash transactions on a daily basis. They don't want to keep cash on premises. And so on a daily or near daily basis, they make cash deposits. And so the IRS was around the country seizing the bank accounts of all these small businesses, making relatively small deposits, usually on a daily basis, because it thought they were structuring their deposits when in fact they were just
doing regular business.
Being responsible businesses and often following the requirements of their insurance, which said don't have more than $10,000 on the premises. In response to all of that, the IRS, that we sued a number of times and won a bunch of cases and got the attention of the New York Times, among others. And finally, the IRS relented and said, we're going to change our policy. We'll no longer do these seizures based on structuring unless there is some other evidence of criminal activity. But that was just a policy change. It was not a change in law, and so it could be changed back at any time. But in the first Trump administration, the Hirsch-Sowers Act finally passed, became law, and prohibits the IRS from conducting these seizures without some other evidence of a crime. But unfortunately, that's the only federal reform that has passed in the past 25 years. We've pushed and prodded and done everything we could to get Congress to move forward on legislation called the FAIR Act for the past 10 years. Each of the past 10 years, we have worked with the sponsors of the legislation to pass the FAIR Act, but it keeps getting stalled out for various reasons. Congress has other priorities or no priorities at all. And so the FAIR Act, which is bipartisan, which passed unanimously out of the House Judiciary Committee a couple summers ago, it just sits by the wayside waiting for, at this point, waiting for Republicans in leadership to embrace it. And nothing has happened with the FAIR Act, unfortunately.
Speaking of policy changes, I understand that what happened to Brian at the airport in 2021 in Atlanta, there's been a policy change to stop that from happening again. Could you talk a little bit about what prompted that change and how it's different now for air travelers?
Sure. So DEA, the agents that seized Brian and his cash at the airport, has stopped conducting airport interdiction as of November 2024. Now, that was a result of an Inspector General report that came out about DEA's airport interdiction activities, finding that they were highly likely to be abusive, that they were likely to involve impermissible profiling, and that the supposed consensual encounters that DEA agents were having with travelers at airports probably weren't consensual at all. That Inspector General report actually came out as a result of an IJ video that we released last summer about a traveler who was at the Cincinnati airport. He was harassed by DEA agents who wanted to search his bag. He fit some profile. He in fact had changed his flight at the last minute because he was sick, and so he had postponed his flight by a day. He was traveling on business. He was trying to get back to New York City. And because he had made this last-minute change to his flight, he ended up on some list that the DEA used for airport interdiction. And so they approached him, badgered him, tried to get him to let them search his bag. He kept refusing while they were sort of stumbling all over themselves in a kind of Keystone Cops routine while they were calling a supervisor. He actually walked around them and boarded his flight. But then they came on the flight and took his bag and searched it and said, I don't care about your consent, because he kept saying, I don't consent.
Right.
And fortunately, he filmed the whole thing so the whole world could see this. So on his phone, we have footage of the entire encounter where they're saying, we don't care about your consent. We can search the bag. They end up, bringing a drug dog to search it, searching the whole thing. There's nothing in the bag.
Right.
He ended up, obviously being let go, and his bag was let go. But we publicized this video because it was emblematic of how DEA treats travelers and how it just abuses people's Fourth Amendment rights in pursuit of cash at airports. And the Inspector General's office saw this video and contacted us and wanted to interview David, the subject of the video, and find out as much as they could about it, get original copies of the footage, that sort of thing. And so we, helped provide them with the materials they needed. And then they also, as part of their authority as Inspector General, conducted other investigations, interviewed the DEA agent, for example, and produced this report that put a lot of pressure on DEA. And ultimately, in response to the IG report, DEA said, we are suspending the airport interdiction program. And DOJ, which DOJ sits above DEA, DEA is an agency within DOJ, DOJ issued a memo saying, we're not doing this until a further investigation is concluded. We're suspending all of that. And then in January of this year, DEA announced they were, they said, permanently canceling the program. Now, again, it's just a policy change. It's not a permanent. It's not permanent through legislation. There's nothing that prevents them from being able to change back tomorrow. But it's still very good news for travelers. At least the DEA can't necessarily seize your cash at the airport. Unfortunately, there are lots of other law enforcement agencies at the airport that also behave abusively. And so it's a little bit of a game of whack-a-mole to try to stop these sort of things nationwide. But that's why we bring lawsuits, to establish precedent that would apply not just to one agency but to others. And so, eventually, hopefully, we'll whack all the moles and shut down airport interdiction as a whole.
All right. Thank you so much, guys, for coming in and talking with us today.
Our pleasure.
Yeah.
And thanks so much to all of you for listening. If you'd like to get more of our videos, you can like and subscribe to our channel. And if you'd like to support this work, you can join us with just $5 a month at ij.org/monthly. Thank you.
Thanks again for watching. Make sure to like, subscribe, and tune in for more videos.